Welcome to the Criminal Justice Moral Fitness Work Group. It is June 5th, 2024. It is 2 o'clock in the afternoon. We're here at DPSST in Salem, and we're using room A235, and we have folks joining us remotely by Teams. Just go through the process. I'll do the administrative announcement that this is a public meeting subject to the public meeting law. Today we're being recorded and the recording will be posted online after. We're not able to stream today because of the technology in the room that we had available to us. Discussion of issues will only be conducted by work group members, and please be mindful of any comments or side conversations. So just to start, we'll start with introductions around the room, and I'll start. Jennifer Howell, DPSST.
Les Young, Bar Public.
Scotty Downing, DPSST and PCC. Other clips.
Mark Daniel, I represent the Oregon Association of Chiefs of Police.
Rob Wood, PPC member.
Angela Brandenburg, Oregon State Sheriff's Association and Police Policy Committee.
Kathy Fink, DPSST.
Carol DeShawn, Oregon Department of Corrections.
Kathy McAlpine, DPSST.
Melissa Langbacho, DPSST Professional Standards.
All right, I also have online joining us, we have Andy Hyder with Oregon State Police. We have Chief Anderson. We have Captain Evie. We have Erica Stolhand, Chief Coleman, Jennifer Lavario with DPSST, Mark Boren from the Corrections Policy Committee, and Cindy Park from DPSST. Have I missed anybody? Okay, all right. So that covers our introductions. And so you had two memos that were sent, and we'll get into those in just a minute. I was going to spend a short amount of time on item number 5, which is a follow-up on pending action items or discussions from past meetings. This one will probably appear on the agenda pretty frequently going forward so that we can go back and touch on a couple of things. But this one is in part going to go back to discussion from last meeting, the ineligibility periods that we discussed in the May 6th meeting. So last time we reviewed the range of ineligibility periods that apply to the discretionary cases that go to the policy committees. The work group found that the pre-employment ineligibility period for, I've lost my words. The work group found that the pre-employment ineligibility period. Oh,
Yeah, there you go.
hi, John, welcome. So when you're talking about those ineligibility periods and you're talking about the pre-employment criminal dispositions that go to the applicant review committee, those were found to be appropriate, and they're currently defined in administrative rule as the 0 days up to 10 years. And the work group was good with maintaining that. For the discretionary cases that go to the telecommunications, corrections, and police policy committees, the current ineligibility period is the minimum of 3 years to a maximum of 10 years, unless there's that finding of dishonesty or discriminatory conduct, which allows up to a maximum of lifetime. And when recommending the ineligibility period, the committee can assign any time frame that falls within that range. On occasion, the length of the ineligibility period may have already been satisfied due to the passage of time. If the start date of the ineligibility period was a date from a past, like a criminal disposition or a separation. And after your discussion last meeting, the work group recommended the 3-year minimum ineligibility period be changed to the 0 days. The work group recommended maintaining the 10 years maximum that applies when there's no dishonesty or discriminatory conduct. But then we encountered a police policy committee case in the meeting that came after the work group meetings, where the committee would have recommended a longer eligibility period if they could have, so longer than the 10 years because they found the conduct was particularly egregious. Now, in that specific case, there was an ultimate finding of discriminatory conduct, which allowed the committee to go to the up to lifetime. in that particular case. But it did remind me that just as we rarely have those cases that warrant having a lesser than 3 years, we do occasionally have those cases where there is no dishonesty, there is no discriminatory conduct, but the conduct is still egregious and the committees have asked if there's an opportunity for more than 10 years. So I just wanted to bring that back and highlight it and find out if there needed to be any more discussion on the 10-year.
Jennifer, if my recollection is correct, that case, it was found there was dishonesty because I initially didn't think there was any, but the committee changed my mind.
Different case.
Different.
I think that one's a different
Talking
one.
about the camera in the bathroom or? a
That-
different one?
Different one.
Oh, a different one.
Yeah.
We found there's discrimination.
Yeah.
Multiple, oh, okay,
Yeah.
I know which one you're talking about.
Yeah.
Thank you,
Yeah.
thank you.
Yeah.
I stand corrected.
But no, that's okay. And it's not necessarily about getting into the like what specifically that one was, but occasionally there does come a time
Yeah.
whenever there's conduct and it might not be criminal. It's usually not criminal because you can apply the fact that there's been criminal proceedings and things have gone into place with convictions and dispositions and probation and those types of things that help mitigate to the 10 years being appropriate. But it's when there's conduct in the workplace that's just egregious and the 10 years is sometimes doesn't seem like enough to some committees at some times.
Mhm.
So it's just a question because it came up just right after our discussion. Yeah.
So Sheriff Brandon, for the record, so we're offering a range, right? We're setting a range, right? So, I mean, is this the time to up that range from 10 years to say 20 years? Leave it up to ultimately the board, but the recommendation for the police policy committee would be more than 10, up to 20, if it's particularly egregious like this case.
Right, it's just how do we allow it, but also recognize that it should be used.
Sparingly.
Yes.
So for egregious conduct. And so I was thinking that too, but then are we gonna set, if we do that, then I think we need to set the parameters of what constitutes egregious conduct. And then that is kind of a difficult because then you're gonna have situations, you're like, oh, we missed one. And so that's my thought process on that.
What about what if you had a thing in there that says to make the maximum, it would need to be a unanimous vote or something like that, where the entire committee would need to agree, or is that out of bounds where normally it's just a vote and majority does the recommendation, but if you're gonna go for the maximum, it would
Right.
need to be a unanimous vote by the committee, which would mean everyone from every different walk of life that serves on these committees has agreed that this is the maximum idea. Just an idea.
Maybe just increase the range to 20 and then the justifications from the policy committees for the conduct.
I mean, the committees still have to go through the same justification process that they've always gone through, and the board still has to affirm it after the committee's done, so.
Right.
You've still got lots of opportunity if you don't think that it should be 20 years. If you're on the committee to speak up, and if you're on the board, when it comes to the board and you read the packet, you can have it removed for discussion at that point too, so.
So, and for history purposes, you know, where was the 10 years? Where did it originate from? And I think for some lesser categories, that might have been a previous maximum, but whenever we last went through the rule changes and consultation with DOJ and that type of thing, the 10 years really also focused in on kind of a maximum that's applied to criminal. When you're using the criminal dispositions as the disqualifier, that the maximum of 10 years is usually the national standard for licensing as the greatest amount of time, absent those extenuating circumstances of the findings of dishonesty, the discriminatory conduct.
Has that been revisited with DOJ?
Uh,
When was the last time that was visited with?
Sure, probably about 5 years ago.
Okay, so not
Yeah.
too long.
Not,
ago.
not too long ago. So I just didn't know if there was even a way to make a distinction between the 10 years and what is eligible for 20 years. And then just for discussion.
Les Youngbar for the record. I think maybe it'd be a good idea for this, for maybe staff to sort of explore some kind of I mean, there could be some kind of language, kind of like having a writer, where you have these parameters, but you say with the exception of something to do with egregious behavior that the committee determines, blah, blah, blah. I'm sure there's something can be worked out along those lines. It's not as crisp, but
Mhm.
it's an out.
And I heard 20 as a general increase amount.
That's. Yeah.
Yeah. If you were 21 when you started and happened your first year, you'd be 41 and things are starting to get slim by then anyway. So.
Any comments from our teams? Nothing in a disagreement then. Okay. Thank you. All right, thank you. I just wanted to, because it happened just right after the discussion, it was kind of like, oh my gosh, we have to talk about that again. Also going back to the ineligibility periods, I want to make a correction on the record. Minor correction to the last meeting statement about the start dates of ineligibility periods. In the last work group meeting, I said that there was a disparity in the cases for separations and cases for criminal dispositions that occur while a person is employed. And I said that the ineligibility period starts from the date of criminal disposition, and that there could be times when somebody who's currently employed and they have their criminal conduct happen while they're employed, they could remain employed the whole time and never have that penalty of being revoked and not serving in their role. So yes, it's true that they could stay employed while the whole time while their case is being processed and heard. So a person is currently employed as a public safety officer. They engage in conduct that's criminal in nature and it goes through the court process. The employer keeps them on while it's going through that court process, and the employer keeps them on while we're doing our case review process. But if the final outcome is that they will be denied or revoked, then because it happened while they were employed, it would be the board start date. And our rules do clearly outline that. I just really misspoke last meeting, so I wanted to go back and provide that correction.
And
So that-
Catherine, to clarify for the record, just to clarify too, is they could be employed, but it doesn't matter, if they're on paid admin leave, they're still employed.
Right.
So they could be on paid admin leave, letting this whole thing get adjudicated, and therefore there's no break in service.
Okay. So that is what I had teed up for follow-up discussion, and I'd be happy to touch on anything else that anybody wants to bring up as a follow-up. Let's try and give a space for that moment. But otherwise, we'll see this one as probably a continued agenda item so that I can continue to give you updates on some of our past discussions and action items. Okay, thank you. So let's go to agenda item 2, the administrative closure criteria. So far, we've talked about the discretionary cases that are reviewed by committees for a determination. However, not every case that DPSST opens results in a denial or revocation, or results in a case that comes before the committees. So today we want to review how and when cases are closed. Staff will open cases when there are circumstances that require the review, and these are outlined in the rules as such things as criminal dispositions, arrests, separations, the falsification of records, when students are dismissed from the academy for misconduct, And then we have our catch-all language of any information that would lead a reasonable person to conclude that there's a moral fitness violation. Our rules also help specify when DPSST can administratively close a professional standards case. If a case is opened, but staff determine that there's no moral fitness violations, so no dishonesty, no misuse of authority, and no misconduct, or if there's insufficient evidence to support denying or revoking the certification, the case can be administratively closed. To provide transparency in that process, those administrative closures are submitted as recommendations to the policy committee for approval, and that process is written into our administrative rules. The policy committee gets to review the basic information that's submitted with that recommendation, and they vote to either affirm those recommended administrative closures, or if they have a question or concern, they can ask more questions and even send it back to staff to be presented as an actual full professional standards case at a later meeting. And it's always done at a later meeting so that we can go through all of the steps and processes to notify the individual, allow them their opportunity for mitigation, and so on and so forth. When the policy committee approves an administrative closure, that's the final level of review. The case is closed and it doesn't need to be submitted to the board for approval. That's also part of the administrative rule. So a case that is administratively closed results in no action against the public safety officer's certifications. The administrative closure process does serve as a record that the conduct has been reviewed and it doesn't impact the public safety officer's eligibility for certification. So your memo includes some discussion items that will help clarify the current interpretation and the application of the rules and DPSST's authority for administrative closures. The first thing that we wanted to talk about were DUI cases, those under the influence cases. So just a bit of background and information. Administrative closure of the DUI resulting in dismissal. Our rule states that DPSST will administratively close the discretionary professional standards cases for deferred adjudications when the only charge is for the DUI upon confirmation of dismissal. So the way that it's written, DPSST is directed to, it doesn't even require the recommended administrative closure memo to the committee. So the rule directs DPSST to do this. The catches are, it's the only charge. When it is the only charge is DUI. So there's a little bit of history behind why it was written that way. Before 2017, a DUI would initiate a case. So DPSST would open the case because we received notification of the arrest through a lead hit or through the agency notifying saying this person's been arrested, they're being charged with this. Everything stays until the final disposition. So if they enter diversion and it gets dismissed, at that time, because the rules only brought forward cases on convictions, because it was dismissed, it was not a conviction, so it was then administratively closed. So went back in 2017 when things were being updated, the work group recommended maintaining that process, recognizing those DUIs that get dismissed don't necessarily rise to the level of a professional standards case. So now the current issue is that the current rule language only allows for dismissed DUI charges to be administratively closed when the DUI is the only charge. And now we see that many DUI cases also include charges that occur at the time of the DUI. Sometimes the other charges are also dismissed. Sometimes the other charges do still result in a criminal disposition. But based on current rules and practices, if there are any other charges, the case is sent to the policy committee for review, even if the other charges are also dismissed. And that's because we have the ability to look at the conduct about the arrest and the conduct that occurred. So the questions that we have loaded up for you, and then Kathy has some data to share as well. First, the rule language refers to charges. So which charges should be used to determine if the DUI is eligible for closure? Is it the arresting officer's charges, the court charges, or either? The second question, should DPSST administratively close DUI cases where there are additional charges, but all charges also result in being dismissed? Or should cases where DUI is dismissed, but there are other charges that result in criminal disposition, should those be administratively closed? Should they still be sent to the policy committee for review? So those were some kind of preloaded questions, but it's really kind of open for all discussion about that particular item. We often get questions about why this DUI case comes forward and why other ones get closed. So Kathy has some stats.
Yeah, Catherine Kaufman for the record. So I looked from 2022 to present day. So there's 15 cases that the policy and or corrections committee looked at. 6 from the policy committee and 9 from the corrections. And 5 of those resulted in no action, and others were a revocation of, anywhere from 3, 10 to a lifetime. But what I looked at is when there was only the no actions, and it really was just a secondary moving charge, was it, but it forced us to bring it forward. So example of a no action just this past month, this was just a DUI out of state, but because they were employed as an officer out of state, got suspended for 6 months. It had to go through the committee. There was no action taken. Another was a DUI and a reckless. Completed diversion led to a lesser charge of careless. The board or committee took no action. DUI reckless, after receiving a sustained finding for misconduct that was terminated by their employee, also had a secondary reckless endangerment charge. The DUI diverted, everything else was diverted, no action that the committee took. 2016 DUI, which is their second, while on probation employment, was a deferred case until hired in 2022, no action. And then there was a DUI, reckless endangerment, reckless driving, but was reduced. The board took no action. So those are the type where it came to the board for action. When things that rose to the level of taking action were DUIs, but also failed to perform the duties. There was property damage, reckless driving. They were revoked for 3 years. That was a recent one. DUI, I pled guilty, but no diversion. Also had assault 4, disrespectful, sexual comments, a whole array of behaviors that ended up revoking the person for 10 years. DUI refusal to take a breath test, violated pre-release agreement on pending criminal charges, revoked for 5 years. DUI with an assault 4, assaulted an individual in a bar, hid from police, but there was a DUI diversion, revoked for lifetime. So, DUI and reckless endangerment while on probation employment, 1 month later arrested for DWLS, so driving while suspended, failure to perform the duties of a driver. There was an accident, there was dishonesty, did not take responsibility. That was a 10-year revocation. Again, a DUI where they did do a diverted sentence. Twice they were given diverted and they failed and chose not to, and revoked for 5 years. Other a DUI, but also pending other misconduct, so it was revoked for 10 years. And then the other lifetime was a DUI, but also unlawful possession of a firearm, 2 counts of reckless endangerment, dishonesty, had kids in the car, tested positive for marijuana, was in a leadership position, lifetime revocation. So when it was a moving violation of reckless driving, and they completed all diversion, looks like both committees would take no action. But anything outside of the conduct of that, it appears that, there was some action taken. So that's why we kind of narrowed it down to your thoughts on moving violations versus the way it is now. And I say moving violations, but it could be broader for Oregon, and so that might be a Washingtonian catch all, but if you kind of understand what I'm saying.
So you're, Mark Daniel, for the record, Kathy, are you talking about infractions versus misdemeanors or felonies?
Well, no, because when I see reckless driving, that's usually a
That's the
misdemeanor.
name of.
And so
Yeah.
in those, it looks like they were dismissed, but because of the way our rules currently are, because they were charged with it, it does not give us administrative closure. It has to come for you. But the committees have always, because again, the thought is they've been very successful through the diversion program, completed everything. But are only coming to the board because of that secondary offense. And then the committees have always, in the last 2.5 years, taken no action.
Was the, Mark Daniel again for the record, so was, in that case, was the reckless driving, was that diverted as well, or was that just simply dismissed as a part of the court action?
On a couple of them, they were dismissed entirely and others were reduced to careless.
Okay.
So a little bit, but all of them were successful in diversion. I figured it would be a little bit easier to give you some context of how you guys have been voting, at least in the last 2.5 years.
Sheriff Banner for the record. So am I correct in, it doesn't seem like it's broken, how it's been working now. Is there just, what does staff think about how this has been going? So these are 15 cases since 2022. So not an overwhelming amount, but because I think it's gonna be hard to try and separate, you talk about moving, moving, it's crimes, so traffic crimes, but hit and run is, hit and run is traffic crime. Which would be something we would want to see, because that has dishonesty and, all the things. So trying to separate out what would qualify, what would not qualify, I think would be a little difficult. So, but it doesn't seem like there's an overwhelming amount of cases, that we would wanna change things, how things are going right now. But I don't know if you have identified any challenges or with this. That's my thoughts.
I think speaking kind of for staff and one of the questions behind it is, it's just so rare to see DUI as an only charge these days, so. Is that pretty much it?
So Rob Wood, for the record, I would assume the level of work and investigation required for the staff is the same regardless.
Correct.
So the proposal or the thought of potentially changing it would only reduce the policy committee's workload. If we took all these cases that there were no action and created some blanket rule that would turn them into administrative closures.
It's a slight reduction, but it definitely is, for the committee. There's potentially, we can bring other cases forward. But again, it's a slippery slope, so you just want to have that conversation of what has been the tendencies of the voting outcomes, but also the nuances, as Jennifer said, where we're rarely finding just a standalone DUI. But was it ever intended? And of course, I don't have the history of how we got to that point other than what Jennifer just explained, but back then maybe was it standalone, but now you get always the, if it's just a straight up DUI, have a moving violation, I stop them. So no accidents, no other calls for service because they were disruptive. And, there's a secondary offense and it's usually the driving portion, speed or something like that. Is the question is just out there, was that the intent of administrative closure? And is there some thought to administratively closing those? If you can define it. And that's why I wanted to give some context of what things actually rose to action. What other things, beyond the DUI that took place that caused action, and can you clearly see clear delineations.
I guess, Robert, for the record, I'm gonna make this maybe a proposal that I agree with Sheriff Brandenburg that if it's not broken and with the risk, maybe else as slight as it could be, that something would slip through, I would make the proposal that we leave it as is.
It's got down for the record. I think with the DUI, the devil's in the details, just because the person is not found guilty, but the policy committees look at the person's behavior, because when you're a law enforcement officer stopped by another law enforcement officer, we've also had police policy cases where the law enforcement officer stops another law enforcement officer, has been put in a bad position and made a decision based on friendship or knowing this person or whatever, and now they're in the grease. And so I think the reason that we look at these cases where you wouldn't if you were just a civilian getting a DUI is because you're held to a higher, different standard. And I think having this policy committee have a set of eyes on, yes, you screwed up, yes, you got a DUI, but what's the details of it? And that's, I think, what's moved the needle for the policy committee that we've been on. If the person took the ride and, didn't do a whole bunch of extra things or put the officers in really precarious positions, then, I think that's when we've taken no action, when they've, taken accountability. So I'm with you. I agree with all. There's a lot to say that I agree with you.
Les Youngbar for the record. Yeah, I would have to agree. I think it's particularly important, that you not change anything that would result in not sending to a policy committee like a reckless driving or any of that, because I think all those merit review. Sure, there's circumstances to be sorted out, but for one thing, I think it creates a better public perception if that's reviewed, and puts less pressure on staff to make those kind of decisions.
I think John might have something.
Sorry. I was just gonna agree. I don't think it's broken, and I don't think we should try and fix it. And personally, as a corrections policy, I would like to see anybody that has anything more than just a DUI in front of us. I know kind of it from experiences in law enforcement as a patrol officer. Sometimes officers stack stuff on, but there's usually a reason for that. And so if a diverted DUI is just an administrative closure, I'm good with that still. But like the reckless or anything else, I think it still should go before policy committee. I think that's just the way it should be.
Yeah, and we appreciate that. That was kind of similar in line, consistency with the discussions on dishonesty, right? When there's this minor versus big, and you said anything that has the appearance of some sort of dishonesty, omission, you want to at least have a committee review that. So I definitely, staff appreciates the input.
Now I want to turn the coin over and look at it from another side. In that, again, DPSST has the authority to open cases based on the conduct related to the arrest, the criminal citation to appear, or its equivalent. So it doesn't have to have resulted in the criminal disposition. It doesn't have to have resulted in the diversion. We have that authority per administrative rule. But the rule says that DPSST will administratively close these DUI cases when it's the only charge and it's dismissed. That's a unique carve out. It's the only thing that DPSST is directed to close. It's the only diversion that's recognized. And what if DPSST looks at the records and can identify egregious conduct within that DUI? And it's just the fact that it was the only charge and it was successfully diverted and dismissed. Because we have to recognize the DUI itself, by itself alone, is already misconduct by violating criminal law and threatening or harming persons and property. So the question is, does it remain appropriate for DPSST to always close those cases? Should it be a may close those cases and then they become those administrative closures that go to the committees for approval? That's the other side of the coin, this unique carve out that DUIs can be closed. End of story.
Do we have history on when this happened, like when that carve out happened? Can you tell us the history on that and the?
Sure, it goes back to that before 2017, it was convictions only. And because a diverted DUI became dismissed, there was no conviction to bring forward for the committee to review. And because it was kind of the current practice, and it was recognized that or perhaps there was thought that there are lots of DUIs that happen. Did the committees need to be tied up with a DUI that is successfully diverted? But now we're several years down the road, we've had time to implement these standards, and it's just kind of a recognition that if we can bring forward any other case based on the conduct of the arrest, the conduct that exists, why does this one stand
And you
alone?
don't know what you don't know, because you don't see it.
Right.
It's got down there, so that just seems wrong to me, if the
Mhm.
person doing the investigation is like, well, there's a lot more to this.
Yeah.
Than just whatever, but they can't send it forward, that seems like that's not in the spirit of what we're trying to do, so
Right.
my recommendation is that we changed if during the case review, someone sees something that raises, I mean, folks who do these cases, they then sit on the policy committee, so they know what the policy committees want to see and what they think. So if it's raising they're really the kind of the first gatekeeper of are we doing the right thing or not, so my recommendation is to change that.
I didn't know for the record, so,
No, you go.
I agree. I don't think that needs to be there because I trust staff to, look at those and then bring the appropriate information forward. And, certainly if it's been diverted, but there's some other type of aggravating factor to this DUI, kind of limits your ability to bring it forward.
Robert, for the record, I was gonna say it was basically the same thing. I would think that staff wouldn't want anything that's somewhat subjective. It seems like you would want just objective things, and if there is something besides the DUI that was egregious, I would agree that you need the avenue, the mechanics to bring it forward to the committee.
Online? Go ahead, Lee.
Lee, for the record, I would agree, I would change it to may. I think the intent of finding some egregious act or action, for instance, if there was some notion of some type of bias or something, the academy is required the board to bring to the board. It would be the same way here. We would want to tie your hands to close it based on some other egregious act. So I would think it'd be may would be more appropriate under the circumstances.
Any other thoughts, comments, or questions about DUIs and DUI cases in general? Okay. So my summary of the conversation is that we will look at taking that carve out for DUIs that are dismissed and changing that to fall under we may recommend the administrative closure to the policy committees. That way there's the review. If egregious conduct is there, then it can still move forward as a case that can be reviewed in total. And that falls in line with the authority to look at all those other criminal activity that may not result in a criminal disposition otherwise, still falls within the existing authority.
Yeah, and I just would like to invite Jennifer or Melissa on a comment, is just whether or not in recent memory, without getting the details, did you read one where you said, I would have liked to have had this, or there was some other conduct that I would sure have liked to have been able to bring this forward?
Yes.
Okay.
Yes.
potentially trying to use their role as a public safety professional to prevent, getting arrested or having to do any field sobriety testing, but do ultimately participate in those things, just sort of ask the questions or make the statements during their arrest that's like, why are you doing this to me? I'm a police officer. You're ruining my career. That sort of thing comes to mind.
Jennifer, did you have anything else you wanted to add? Okay, all right, thank you. Okay. All right. So talking about some other circumstances in which an administrative closure might be appropriate to consider. Item number 2 says maximum ineligibility period reached. So every once in a while, there are cases when a public safety officer has a criminal disposition or a separation from employment that requires review by the policy committee, but the maximum ineligibility period, which is currently 10 years for the conduct that didn't include the dishonesty or the discriminatory conduct, but that timeline would have already passed. So the conduct can still be reviewed. The committee can still find that it's misconduct and need to take and decide to take action. The maximum action that they could apply is 10 years. So it's already passed. Is this something, a set of circumstances in which it would be appropriate to be presented as a recommended administrative closure?
So our first agenda item was potential changes.
Right.
In that case.
Never mind. Yeah. So I wrote the memo before. But still for discussion.
Well, I would say if it stays at 10 years, then what's the purpose of bringing it before the policy committee? Am I missing something?
So Sheriff Brandon, for the record, so
Yeah.
if there is, because if you just administratively close it, it doesn't show anywhere on the record, their record.
As an action, not as
There's
an
no,
action.
there's no action,
Right.
there's no action. So if I go and do a cursory look,
Mhm.
it shows this person has been certified, no problems at all. So I would say, even if the policy committee reviews it, and finds there's a finding at least that shows on the record, the
So
record.
wouldn't you say applicant, why have you been out of business for 10 years?
Well, we would. I mean, we have a pretty good process, but there's some that don't, or, maybe out of state, or,
Mhm.
so I just think that as a matter of, ensuring things are all on the record, that you have this information, and if you don't show a finding
Yeah.
and then record it on their record, it's like it never happened.
Yeah.
That's right, am I right?
And the only
I
reason
hadn't
it's
thought
coming
about it from that
before
angle.
us is because they've now been potentially hired.
Right.
Okay, so
Yeah,
that gets
okay.
us to
Yeah.
the point.
But then it's there's no penalty, but the penalty is that there's at least a mark that
Right.
shows that there was this conduct
That's good.
Yeah.
and records associated with it.
Right, and you could still take the action to deny
Yeah.
or to revoke, and that would be, the
Right.
certifications were revoked. It just means that the ineligibility period may have passed, and then they can already go right into the new process.
Right.
So you're saying this has happened?
It does,
It happened.
it does
but
happen.
Defining but it was after the 10-year period, so there's nothing to revoke. Is that the bottom
The
line?
certifications were,
I mean,
are
it
there,
was
they
revoked.
exist, yes.
Yeah,
Or denying the ability to be certified. Because you're saying that the moral fitness violation exists and the circumstances of the conduct and the aggravating circumstances were so do rise to the level to say, no, you can't be certified. Now the 10 years has already passed, but
Yeah, so it's generally gonna be in those deferred cases and,
we have some information coming in online. So, Chief Coleman?
Yeah, thanks, Jennifer. This is Jim Coleman for the record. I hope I'm understanding the conversation. I think I am after listening to the other comments. I don't think it should be just administratively closed. I think there needs to be some sort of weighing in of, some sort of commentary as to, you know, or in consideration of the fact that they've been out of the career or, somewhere else for 10 years, some sort of language like that, where you could say, for lack of a better term, credit for time served. But I do think it needs to be more than a technicality where it's just, if I'm understanding correctly, administratively closed, because I think it would give the impression that the person chose their own outcome and own correction versus DPSST having a say in that.
Thank you. Lee?
Yeah, maybe for the record, I agree with Chief Coleman and Sheriff Brandenburg. I do not support DPSST administratively closing these cases. I'd rather them go to the board and let the board hear the facts as they are and make a determination on the record itself, and whether that obviously doesn't affect or affects that individual. I think there needs to be a record.
Okay, for the record, I just have kind of a side question. So if someone leaves the profession, they have this situation occur, and they're gone for 5 years. They're no longer certified anyway. So they, at the 10-year mark, if they decide to come back, and this case is held in advance, I mean, where does it really need to go? Because they're not even certified at that time.
Could I explain, I guess, the case that prompted me to ask this question, if that would make any sense? So, there was a situation where a police officer had, left employment with their agency and left the professional standards, role and, worked in another field. And during that time period, or had, criminal charges that occurred. They were not reported to the EPSST for us to review because it wasn't required at that time. And then down the road, years later, they re-entered the workforce, and reported the information for us to look at that time. And the allegations, I think that, or the criminal charge that they had was like offensive littering. So it wasn't something that would really impact their employment. And that 10-year time period, which would have been the maximum that the committee could have prescribed for that criminal disposition, had already lapsed. And so it was sort of something that was like, is this something that should go to the committee? And we just wanted to reaffirm that we're doing the right thing and taking those. Because it isn't sort of laid out very specifically what we do all the time.
Yeah, sometimes we find that our rules just don't cover the situations. And so we're trying to make sure we have something that will give us direction to cover the situations.
Jennifer, Jim Coleman, one more time. Seems like it would be wise also to make sure that it's somewhat in alignment with what happens when officers resign while under investigation. I mean, if a person reasonably knows that they've, had a criminal charge or conviction, but it doesn't come to light, I mean, they're kind of in the same circumstances leaving while under investigation. Just seems like there should be some consistency there.
And I guess that's kind of roundabout, Mark Dana for the record. I guess that's kind of roundabout how I was kind of thinking about this. Because if they left the employment during this kind of weird thing that happens, they're gone for 10 years. And like I said, their certification's gone anyway, because they've been out for 5 or more. So, it's when they come back, it's kind of like that whole thing all over again, just like Jim was saying. But I'm just wondering if, are we looking at retroactively, decertifying them for that 10-year period? And then going back and showing on the record that they're then, decertified for that 10 years? And then at that 10-year mark, because then are we looking at whether or not they can move forward from there, based on their application and all that?
I would say yes,
Okay.
yes.
So Sheriff Brandenburg for the record. So now there's a change as reporting requirement about if you're charged criminally, you have to notify. So is this a problem that's gonna be going away because of that fix? Because if somebody was in that, and they was in that situation, failed to report, well, that's very different. And that's something that would come to the policy committee. Am I correct? Because they failed to report their criminal citation or arrest or whatever. Yeah. Is that problem gonna be going away? Is it timing itself out?
Maybe with the other fix, the other scenario, so I wasn't familiar with Melissa's particular one, which, you know, is a nuanced. The ones I was thinking is the deferred cases that depending on how long it takes for somebody to reconsider or to have somebody hire somebody who was dismissed, let go during either the academy or during their probation, and so they never had certification. And whatever it is that they got terminated for, it rises to a level of potentially a professional standards case. Now, let's assume we don't fix what we asked you guys to look at the very first meeting on. You could have that lapse in time. Maybe somebody really took 10 years, maybe they were 21 years old at the time when this happened. And so 10 years, 31, they're going, okay, I want to try, I'm a whole different person and a whole different perspective. You could potentially see then a 10-year-old case
Right.
in front of you. And whatever they did, just short of a dishonesty, I think the concern is it's a moot point in the sense that you can't really impose anything greater than, as we know it today, 10 years. And so is it something that the committee would recommend that we administratively close that because we know it? Or as I'm hearing some of the discussion, there's value in having to come in front of your peers and, you know, be held accountable or to articulate why you're no longer this person. And, but though that could be still a scenario of a deferred case, that has all the time limit lapse.
John?
John Frost for the record. Hey, I was just thinking about the case that we just had before us on corrections policy, where a young man had been charged with crime. It was, if I remember right, deferred. Something happened. I can't remember. And the first time they came in front of the board, we gave him, I think, 10 years. And then there was some kind of a procedural error, so he ended up coming back in front of us again. And on the second time around, oh no, we gave him lifetime, if I remember right. And then the second time around, we gave him 10, I think it was, and he was good to go to work. And I don't remember what it was that it was, but I remember that he had so much more support the second time around from the first time. And with his agency and everybody else. But I still like the fact that he came before us and had to explain himself. Even if we had to do it twice, I think it was better that way. And he did, he really was remorseful about his actions, and he really was like, hey, look, I really did screw up when I was 19 years old, and now I'm trying to get my life where he wanted to be in law enforcement. So personally, I think these should still come before us. They shouldn't just be an automatic pass.
Thank you. And that's what I've heard from each of you, is that just because 10 years have elapsed since the criminal conduct or the separation of employment doesn't mean that it doesn't warrant the review. The review process is critical in making those determinations and having that record of conduct has been determined to either affect certification or not affect certification, but it shouldn't just be administratively closed. And we're not talking about a lot of cases, so it's, yeah, it was just kind of a,
I think the other thing that we heard, Catherine Calpine for the record, just again, give full information, when we did our recent, listening tour. And it was more of a question because obviously most of these agency heads have probably not sat on a committee to know the details. But there was a level of frustration because sometimes, as you know, it can be several years that have gone by before you're actually, having it before you in the committee. And the feeling was, this is so negative on the department. We've kind of moved on, we've dealt with the issue, and even though it's about an officer certification, whether it's through the media or somebody else, it kind of brings up the scars again and basically, can't you do something about that? And I think just when we know that time has gone by, almost always out of circumstances outside of the control of the process, they're necessary to be heard, and we can't always control the timing, and depending on the conduct of the individual, it could bring to light that agency yet again and have some coverage. So just want to share that, not as an action item, but just, we did hear that from some of the agencies of concern on timeline and then having to relive these events again.
the third item that is in the memo is really more of a, just a comment or an awareness, and that is that cases can be opened in error. And don't technically then require an administrative closure process. We opened it and then, oh, we found out that it's not that type of separation, it's a medical separation. So because there's no review of misconduct, because it's medical, and we don't need to go through an administrative closure process. But again, our rules don't clearly outline, because we've opened a case, our language is about opening cases and administratively closing open cases. But if you open it and it's opened in error, so just, we might have to put something forth in administrative rule that just acknowledges that situation and scenario. Oh, Jennifer, you have your hand up.
I'm sorry, Jennifer, but I'm going backwards a little bit to administrative closures just to make sure it's on the record. Jennifer Lavario for the record. I don't recall the committee talking about when to consider a charge in the administrative closure with DUI. So I just wanted to make sure we didn't miss that piece. So whenever we go back to that, just wanted to make sure the committee had a chance to chime in.
Thank you. Okay. I think we may have resolved it in that we weren't going to, so currently close a DUI if it's the only charge and it's been successfully diverted. But we're looking to propose changing that to the recommended administrative closure process, so that DPSST may recommend an administrative closure, meaning that DPSST could still put forth a case.
Correct, and maybe I didn't hear it accurately, but one of the questions we have when we get cases with a DUI and an additional charge or two is, at what point is that considered a charge? Is it at the arresting officer's charging, or is it at the DA's charging?
Sure, Brandon Burke for the record. I would say the GA's charge, and that's typically what we use for our agency. Sometimes the DA's office will get it and then they'll decline the case and it's never charged.
Okay.
My opinion, anyway.
So is that the equivalent, just for me, for language purposes, is that the equivalent of a a court process
Yeah, so-
charging versus the arresting charges.
Right,
Yeah.
so probable cause, then it's to the DA's office for formal charges.
So if they reduce the reckless driving or something right then and there, then we would not bring it forward, because it'd just be a DUI.
So
Where currently, it's because it was, the officer had these additional charges, and at some point, they may be adjudicated down or dismissed, but it's throughout the process. Those you guys have been seeing. And I think that's why
Yeah.
the clarification.
So. have
I
we-
guess when I'm sorry. I guess
So
when we
the-
see it on the docket, that's when we consider it a charge.
So have you seen cases, and maybe some district attorney's offices are different? But typically, I think that even for them to resolve those charges, they accept it, they do formal charges on it, and then enter the negotiation part where the district attorney, can decide what they want to do with that. So I don't know if you guys have you had cases that come before you that have not been formally charged by the district attorney and gone through the process of having it reduced down from a DUI to a something or.
It's sometime, yeah, go ahead, Melissa.
Mostly Basha for the record. I think, something that comes to mind, is that if it's reduced from reckless driving to careless driving, that could be on a separate court case, to delineate between traffic stuff and criminal charges. And so sometimes those get separated out that way, and we don't necessarily see them on the same, charging document from the DA, but it's the same incident that both of those things occurred in. And I guess kind of confusing to us on what we consider a charge. It's in the same case. It's separated out, in the court system. If it was originally reckless driving by, the police officer, but reduced to careless driving, for instance. I guess that's what comes to mind for me. And Jennifer, did you have other, or Cindy too? Cindy looks at a lot of these as well.
Yeah, that's some of it. Of course, the charging officer may have 4 or 5 different charges. By the time it goes to court, it's DUI and reckless, or DUI and assault 4. If I see, my practice has been, if I see those 2 brought to charge, that's what I'm considering something I'm bringing forward to the committee. Even if that's part of the plea bargaining that gets him to deferral, which behind the scenes, I'm not seeing all of that. I'm just seeing it in e-courts, really.
It's Scotty Downing for the record. I think again, we could lose the nuance of what happened because DAs can
Yeah.
say, hey, there was this big riot and half the city got burned down, but this is a political deal, and so no charges on any of them. Well, it doesn't mean no crimes were committed. It means no charges on anybody, or their office is extremely overworked. So they're like, hey, all misdemeanor charges with no one with any criminal history are gonna automatically just be reduced. We're not gonna do it. And then we would see it. And so I think that, like I said, the devil's in the details on these cases. And so I think you risk missing going on, because the DA, hopefully the officer is not making political decisions on arrest. They're using probable cause and facts to make these arrests and give charges that they could justify in their documentation, where the DA has ultimate authority to prosecute or not. And-
Beyond a reasonable doubt.
Right, they have to prove beyond a reasonable,
Right.
right, but even if they think they can prove beyond a reasonable doubt, they have no obligation to go with prosecution. They could say in the interest of justice, they could say in, we don't have the staffing, they can say all sorts of things, so.
Mark Gainer for the record, I agree with Scott, and I was wrestling over the fact that, we've got 36 different district attorneys in the state and 36 potential different ways of handling these cases. So I kept reflecting back to our conversations about Brady and the fact that, Brady has looked at 36 different ways in this state. So I feel like we need to find a consistent way to look at this. If there is a way to do that, because, you know, whether or not the DA is charged or not is, I agree, it's sometimes political, it's sometimes, a different way of making decisions.
And we're taking a look at it as well, so if the DA, the officer makes the charging decision, the DA drops these, and the policy committees are reviewing them, they're saying, oh, I see why they dropped them. Well, we have that flexibility to agree with them there, but we at least still see it.
Les Schoenberg for the record. Can't say I disagree. I think it's to me, what's important is that we're talking about conduct, not necessarily criminal act. I mean, you know, when we're talking about officer behavior and reviewing these or corrections officers or police officers or whatever, we're really talking about conduct. Because sometimes the conduct rises to a level where it doesn't matter if it's criminal or not. You know, so I think it's important to keep that in mind and continue to review these. And it's too bad about the confusion about charges for you guys, but I mean, I don't know if we should get too hung up on that is all.
It's a hang up for us.
Yeah.
That's why we're seeking clarity because, and we want to apply it consistently. And that can stand the test of time. And so if there is a definitive thing where we can say, we'll go with what the officers charge and anything can happen down the road almost immediately to the end. But if there's anything outside of the DUI that's added onto it, we want to see it. Because again, the nuance in the DUI is it gives us the authority to administratively close it. And if there's nothing else. And so just want to make sure that if that's the intention, another scenario that it could be is, again, when you talk about DAs versus what we're trying to hold people accountable for is individual being in contact for a domestic situation, pushes an officer and says, you know, get out of my house. And they charge him with assault of an officer. And before they're booked, they drop that charge. Does the conduct go away? You know, it's one thing if you know, would you not apply a criminal, you know, but, and let's just assume that all the other things are met. They've identified themselves as a police officer, so there's a nexus. But the behavior is, you know, in this scenario is immediately upon arraignment, they drop, you know, because we all see it, you know, officers can be assaulted and they're expendable. But, you know, the conduct didn't actually occurred. It didn't go away. They just didn't charge him with that. So kind of giving you, we have certain scenarios, but we want to make sure we see all the variables when you're kind of guiding us on what you would like to see. So that's why it's important for us to kind of get a distinction of at the time of arrest, the charges that were determined, or is it what they were actually, the court charges eventually?
Sheriff Brandenburg, for the record, so what I'm hearing, and I'm swayed to your argument. Is that, I mean, there was conduct that occurred for the charge and the police officer who were out doing the work every single day. And whether it's a police officer or a citizen, that conduct, if they're charging that police officer, that's the conduct we should be looking at.
Right.
So I would say it would be the charging.
Because historically, that's what the agency does. They look at the conduct and not necessarily what the outcome is gonna be. And therefore, is the certification process part of the conduct versus the outcome?
And marketing for the record, and the mitigating factors that the committee, and you. That person paid restitution, or they accepted all the behavior, they accepted their actions. You know, those would all be mitigating factors, right? But I think the committee should definitely, have the opportunity to review, the conduct, of the officer or public safety professional, based on their conduct, at the time of their arrest, if you will.
And Scott, down the records, we had one recently where it was a hit and run with property damage. the folks came back the next day when they were clear ahead, they fixed the damage and then reached a civil compromise. Well, it doesn't, and so the criminal charge goes away. However, it doesn't change the fact that that night, they crashed, they damaged
left.
property, and they left. So,
Yeah.
sound familiar, yes.
I may, Rob, wait for the record, I may be oversimplifying this, but this is all discussion on when something should be administratively closed and when it should be come before the committee, correct? That's what this discussion's about, and this may be oversimplified, but what if there's only a charge of the DUI, only that charge and underlined, there's no evidence of misconduct, misuse of authority, or dishonesty. It'd have to be an and then in that case, staff could administratively close it. But regardless of secondary charges or not, if there was evidence of one of those three things, that's something that would be presented to the committees.
Right, and I think that we pretty much got there. And that with a slight adjustment that DPSST staff wouldn't just close it, we would send it as a recommended administrative closure to the committee. But this was going to that qualification of it when it's the only charge. And the question of, well, what is considered a charge, but based on the discussion and the feedback, it almost, what I'm taking away from it is that we should continue to apply the broadest interpretation of a only charge being either the arresting officer's charges or the resulting criminal charges. So if a charge is done on either side, the arresting officer's charge or the court's charge, a charge exists, therefore there's conduct to continue to review.
So I think Sheriff Brandenburg, for the record, I think we're getting hung up on the word charge because police officers don't charge.
Okay,
We arrest.
okay,
So the DA's office charges.
okay,
So I think that's probably contributes to some of the confusion. So it's the arresting officers. So it's not necessarily we'll charge them.
okay,
So offenses. So there may be some language cleanup that might help
Okay.
clarify. So that another committee isn't here in 10 years going,
Mhm.
what is that?
okay.
I mean, just to help clarify.
Say that arresting,
Offenses.
Offenses.
Time of the or something like that.
Yeah.
Yeah.
And the DA charges.
okay,
We arrest on probable cause and the DA's office charges.
okay.
So good turn.
Jennifer, did that help? Thank you for catching
Yes,
that.
thank you. The
Yeah.
language was really the hang up like Sheriff Brandenburg was talking about. So I appreciate the dialogue.
And thank you for bringing us back to it. Okay. So, go ahead.
Yeah, it was, I think we're going back to cases open in error.
Well, and just acknowledgement that there are sometimes cases opened in error. And that it may be helpful if we just insert something into administrative rule language that says that they don't require an administrative closure process. So that we aren't creating those basically public records. So, let's see. And I'm happy to answer any other questions about something like that. Let's see. Item number 4 is that broader question of, are there any circumstances where DPSST should be administratively closing a case without action? Some of the potential scenarios that we've come up with are, if the public safety officer is deceased, then perhaps administrative rule language that directs DPSST to close it. It wouldn't go through the recommended administrative closure process, but we would just acknowledge that the individual is deceased. That would be the reason for closing. And then there's the difficult interpretation of what is performance-based. If the conduct could be considered performance-based, then DPSST may recommend administrative closure to a policy committee. But how do we distinguish between performance and moral fitness? and if there were any other scenarios that the work group wanted to discuss or bring about.
We've had, Robert, for the record, we've had a few cases come before us that we personally have questioned why they come before us, and then I realized you have to err on the side of caution. So I understand that, but it's clear that the employer dismissed these people, in my opinion, for performance-based issues. But an investigation ensued that expanded it beyond that. I'm not suggesting we make any changes, but we've had a number of them recently that were definitely performance-based and not a moral fitness issue.
I think Sheriff Brandenburg for the record, and I think that the policy committees recognize it fairly quickly, and so to err to the side of caution of having them still come before and recognize the police policy committee or the policy committees, I think recognize what performance versus, misconduct is, and it's been pretty quick.
It has.
So,
What's not been quick is the review of the case, but it's quick to decide that, yes.
so you get paid big dollars.
State dollars.
But the staff time for those as well, right? Is it, so,
Right, and some of I think we all know that you can pretty much put anything under negatively threatens the efficient operations of an organization. And so when I'm providing direction or we're discussing that, if that is part of the articulation of the termination, then it has to be at least vetted out for this body to consider whether or not that's strictly performance-based, or in fact, they do see that impacted the efficiency of the operation, because a lot of their performance does. And so when it gets into that gray area, you're right. My direction has been, we're gonna err on the side of bringing it forward. But if there's any way we can articulate this further, then, looking for any type of direction or suggestions.
Can I add to the context where I get confused? Melissa Langbasher for the record. So we have as a mandatory revocation criteria, excessive or unjustified use of force. And I think that there have been situations where the committee will review situations that haven't resulted in the termination of an officer because they resigned in lieu of termination, which eliminates it from being a mandatory revocation for DPSST and kicks it to the committee for the review. And sometimes those scenarios, we're not looking at how egregious it is, just a yes or no. Was this a separation for excessive use of force or an unjustified use of force that can sometimes be for performance-based things. Because it almost was a mandatory situation, it feels like something we should have the committee look at, just because someone resigned instead of allowing their due process to happen for their termination. And so it is sort of like, I don't know what to do with these. That's one scenario. There's obviously others, but
So I would, in that case, Robert, I would support that the staff brings it before the committee.
Yeah.
Like the fire recently at the docks. That's one right there.
So, however, Sheriff Brandenburg, for the record, if it's just not just, but the threat or harm, the efficient operations of an agency, and it is tied to performance, is that something that is easily, you identify that as staff? Do you go, this one sure looks like this is where the policy committee's got to look at this and they're going to rule on it? So, because I think it comes to what you've been doing this for a while and now you have expertise of Kathy here. Does this open up pathways for you to go, this is how the policy committee will look at this, and I believe, and so can we give you some of that latitude? Because you have that expertise in here as well. I think some of it is about making sure we bring the right cases before us, but if that makes sense, am I talking in circles? So just trying to give you some of the to get some of that gray and take care of the gray, when you're like, that is my experience as a chief of an agency, this is performance related, and it's just affecting, not just, the efficient operations of an agency. Does that make sense? Because we've had some of those.
Let's know for the record, the difficulty is we may not always have Kathy or a person like
Right.
that. So I think you have to do the language broad enough that anybody, any of the rest of the staff can feel comfortable making that decision, whatever language would be helpful. I don't know what that would be.
Okay, for the record, I just wonder if that puts Kathy in a really bad position. Because just knowing and taking a look at chiefs and sheriffs across the state, we all look at things differently. And what we might consider would be affecting the efficient operation of our agency may not be what another CEO of an organization is going to feel that way, or vice versa.
Right, and so just, Captain Coppin, for the record, what I can speak, again, having really the distinct honor of being on a committee and making those tough decisions that we're asking all of you to do. And thinking some of those myself, why am I seeing this, or any number of those, and coming here and having a conversation with staff. One is I do provide 37 years of policing, so just even talking about terminology and what this means is helpful. And now that we have Kathy Fink and does the telecom, we have a broader range of discussions. So to paint a picture of the day-to-day is, this will be roundtabled. First from the case managers, but then eventually it goes to Kathy, then it goes to me. They're not gonna give me the easy ones, it's gonna be those gray areas. And like I said, right now, my direction has been, if it is in the gray area where it could be subjective, I'm gonna bring it to the committee. For those reasons that I don't, first of all, I'm gonna always try and check my biases if I have an opinion or anything else. But really this is so important on both sides that I'm gonna bring it to the committee to have the thoughtful discussions, to have the officer be able to provide any verbal or written mitigation. But performance-based is tough because embedded those could be some deceit. Not a clear line, but there's deceit, there's things of that nature that it's gonna take a group to sit there and vet and discuss it to see if that can be contained. And I would rather have a group of peers and subject matter experts vet those out, be the devil's advocate both ways to say, no, that's within the performance and we're gonna keep it as performance. Versus I'm gonna pull that out and say, yeah, they were lying by omission or deceitful or things of that nature. So, but I do often see, which is why it's in front of you, where we do hear, yeah, we think that's based on performance only. But hopefully you'll see those in just the very grayest of areas.
Jennifer, you wanted to add a comment?
Just in the interest of the terms or the language in the rule, what I know from being on different committees, having to present to different committees, is what affects one agency, say DOC, may not affect police the same way. What may be disruptive to telecommunications may not be disruptive to DOC. So having some language that is a little more specific to what you are looking for as affecting or harming the efficient operations of an agency may help us narrow that down a little bit. I don't know.
I'm thinking whatever proposal we come up with is gonna create more subjectivity, because first thing popped in my mind is if the lack of, if it was a performance issue because of lack of experience or training.
Right.
Well, that in itself is subjective. So I don't know how we adjust, address Jennifer's concerns, how we.
Yeah.
can't get their work done, if they're 20 officers short. You know, it's like, there's some, there's a lot more.
Chief Anderson?
Hey, thank you. I want to make sure I can articulate this well. I'm just wondering if we're more clear about what the definitions are. So when I think of performance issues, it's clear that they're in certain areas, such as maybe attendance, tardiness, customer service, just specific things, but really outlining where it would become more of a moral fitness issue, like an ethical issue, because they're so very different. And I think that an agency needs to be able to terminate an employee who is not meeting the agency's needs, but DPSST, doesn't need to get involved unless there's a moral fitness issue. I don't think we want to hear and know about every performance issue termination. That just seems overwhelming in policy and practice.
And Melissa Langbosher for the record. So just to add to that, so it's not just unjustified and excessive use of force that are in the mandatory criteria. It's also violations of rights and preventing someone from doing anything that they have a legal right to do. And so a lot of those things veer towards that potentially performance-based issues. And so it does make it challenging to figure out where that line is from mandatory to administratively closing a case.
Well, I wonder if sorry about the hand keeps going up. I wonder if there's a way to fix that as well by adding something like intentionally, much like we do in our ORSs when we're holding folks accountable. We look at knowledge, we look at intent, we look at all kinds of mental states. Because there's a difference between somebody who just didn't have the training and has zero intentionality, and somebody who is setting out to violate somebody's rights. But again, it's complicated, but maybe worth going down that road of seeing if we could do it in a way that meets the needs of why those things are listed under moral fitness.
I think Jennifer, correct me if I'm wrong, there's an intentional reason why we don't have intentional in misconduct. So, Chief Anderson, to your point, we have intentional for dishonesty, we have intentional for misuse of authority, but because of the array of so many variables, we don't have we don't have to prove intent in the misconduct. So I think it's always factored in, whether it's explicitly or inexplicitly talked about in the facts, but that isn't one intentional we don't have to prove. The other thing that again is challenging, and Chief, I'll point it to you because you know it in a recent case where the board listened to a case where there was a termination because it really put not only other responders in a safety risk because of their lack of performance and ineptness, whatever it is, but it was so egregious, they were terminated, came to the policy committee. His testimony was, training, I meant no harm to do this. And long and short of it is the committee took no action. They saw it was a performance issue. But again, the decision at the home agency was this was pretty egregious. It really put people in jeopardy and therefore I'm letting this person go. And again, I don't think that it was ever intended to mirror these two. They stand alone because the certification or decertification is in some ways such a higher bar, right? Because now you're talking about being able to do this profession in the state that they live in. And so I think that's another thing that we have to look at is the agency is well within their right because they know the facts intimately. And then you're going to come here and review all of it to include testimony and whether or not, you find the same things that a decertification is relevant. So if we can define performance-based and narrow it down, I can probably, if the committee would like, I can do some data drive to give some recent examples if you need them, for when the various different committees thought they were performance issues, if that's helpful, or not necessary, whatever.
It's going down for the record. I think it's important to clarify that what may be a performance issue somewhere worthy of termination, or even like this is a violation, this does not work in our community. There's 36 counties, there's so many different communities, and there's different working environments, there's different size agencies. So OSU Police Department may say that type of behavior cannot work here, it will not work here. But if you work in Lakeview, it's totally normal, whatever the behavior the person is doing, because there are different environments. I think what is important, what we're doing, is we're saying, can you be a police officer anywhere? Not at OSU decides this doesn't work here, we're terminating you because you cannot be a police officer in this environment. Well, it doesn't necessarily mean unless there's one of these moral fitness violations. And I think the complicated cases we've had, they're voluminous amounts of paperwork and they're hard to get through. But the committee, I think, realizes right away, this is a performance issue. Not saying the agency shouldn't have terminated them because that's between them and the agency. But should we fire them from the career field in the state? And I think that's when at least the police policy committee has said, this is a performance issue. Is this person salvageable? And when you take no action, then you're saying yes, but you're probably not getting hired back there. So that makes sense. I don't know how we can simplify it. I don't know how. It would be awesome if we could, but I don't see how.
Les Youngworth for the record, I guess bottom line, I would wonder, Kathy, I realize it creates a bigger burden for staff to decide, make this decision, but how much of a burden is it really on the policy committees if you just continue to push those through to the policy committees?
Maybe well, the books are like this big, but I think it's what you sign up for, and you want as much information as possible.
Yeah, it can be attitudinal is what I'm holding back to,
Yeah.
because when you do have 3 or 4 books and you can see the frustration is like, why is this before me? And you hear those every now and then, you take that very seriously. You want to sit there and go, did I miss something? Do whatever. And so I think when you have a heavy workload, you want to only see the most relevant stuff. And if there is, but I will say is, as varying as we have on committee members in each of these, there are varying opinions. So I doubt if I'm going to hit the team, hit a home run every time, and everybody agrees that everything that we said should have been appropriately brought before them. So again, we do hear that they do believe it's a performance issue, but I don't think there's a common theme that I can bring to you that we could narrow down and say, these are what we're seeing these scenarios, and help guide you to narrowing those or defining them.
And I haven't seen one yet that I said, I don't know why I'm reviewing it. I've seen, like, this is a big, complicated, convoluted mess, and once we pulled everything apart and looked at everything, I think it's a performance issue, and that's how I say it, and then usually other folks agree who are, from the career field. So but I don't look at staff and say, you shouldn't have said it. You're like, wow, what a pain to get through, but we have to.
For the record, I agree with Scott. From my perspective, it's not an indictment on the agency. It's not an indictment on CEO's decision to terminate the employment of an individual. But it's our duty to take a look and see whether or not, as Scott said, they should be a police officer or corrections officer or dispatcher from this point forward. And it's not just for the state of Oregon. I mean, it's nationwide. I mean, our decisions are going into a database, which are being used by police agencies and public safety agencies across the country.
One thing that could potentially reduce the workload is if you add a checkbox on the F4 that said, this is employee terminated for performance reasons only.
requires that agencies know and understand our administrative rules.
Right.
That's a
risk.
I think that's a risk. I don't know that we all can agree to what they.
And then you get back to the same issue that you would have with the DA
Yeah.
is this chief or this superintendent gonna think this is more than a performance issue and this one isn't?
Well, and Kathy, thinking for the record, just because of history, you'll sometimes have competing thoughts at an agency on whether the performance has risen to a behavior.
Yeah.
Because they have not corrected it, even though they've tried other things to try to help them correct it. So. And that's why probably you're seeing some of these is because we really can't ascertain that in the documentation that we received with them, so.
I think we're just stuck with it. Good job.
Moving on.
That's why the discussion is there, though. And I did hear throughout the whole discussion that it really, the process is working the way that it's supposed to be working. Yes, there may be those determinations that it didn't turn out to be moral fitness, but it was still the appropriate thing to have the case reviewed. That it's working the way that it's supposed to right now. So, okay. No changes. All right, so this has been a long discussion on administrative closures.
Sure.
Any other questions related to administrative closures? Never hesitate to go back and say, I have one more thought or one more question, even if we've. Okay, so we do still have 20-ish minutes, and let's see what we can do here. Policy committee case review processes. Just wanting to touch on a few different aspects of the case review process as it happens within the committees themselves. So jumping right into that first discussion item, the rule states that policy committees will review the professional standards case to affirm, modify, or negate the department identified moral fitness violations. So generally, when the case is presented, staff will provide an overview of the case. The public safety officer has the opportunity to provide their verbal mitigation, and then the committee opens discussion about the case to include discussion about the violations and the identifying process for those aggravating and mitigating circumstances. There's also a motion to adopt the staff report. That staff report is the record in which the committee's decisions and discussions are based. And so then there were some general definitions that applied to the interpretation of that current process. So what I just said, that adoption of the staff report means the records and the exhibits are what's used for the discussion and the action. If the committee needed more for their discussion or their action, it would be returned back to staff versus adopting it. Affirming the identified moral fitness violations means accepting the department identified violations as they've been stated in the staff memos. Modifying the identified moral fitness violation means making changes to those department identified violations. A change could be removing a category in its entirety. We don't think that this is dishonesty as a moral fitness violation. We'll use it as dishonesty as an aggravating factor, but not as a moral fitness violation. Or it could be something like modifying what's included in the consideration of misconduct. So one example would be there were these charges and these charges, but these charges we're not going to look at, and we'll keep looking at this one. So we're removing a part of what has been presented. So that could be the modifying part. And then negating identified moral fitness violations would mean that the committee determined that the conduct under review does not meet the definition of a moral fitness violation. So the issue that brought it forward for part of this review is that in the past, adopting the staff report without any changes meant that all of the moral fitness violations that staff put in the memo were the ones that were recognized by the committee for action. And so we just wanted to highlight that DPSST has been working to improve the facilitation of this process. And so those of you who are on the committees have probably seen those changes coming. And they're being further refined, but we also wanted to create a space for any additional feedback. So if there were any questions or concerns or recommendation related to that facilitation, it had been included as a discussion item here, so.
Probably for the record, as a member, I think it's a lot clearer now. So first we adopt the staff report, whether we agree with the findings of it or not. Or we don't adopt it and send it back for more information. Then we separately discuss after testimony and after review, whether we affirm, modify, or negate. So personally, I like the way it's gone recently. I think it's clearer.
Sure, Brandon, we're going to completely agree. It's been much more clear, and
And Kath McAlpine, for the record, one, thank you for that feedback, and two, what often you don't see is the next steps, and that's once your decisions are made, that's why one, we repeat now, making sure we understand the aggravating, mitigating, but we slow it down where, you know, in meetings, we can say, well, I can adopt it and I'm also gonna recommend, and it shortens everything. It makes it for a very efficient meeting sometimes, but the cost is it's not clear to maybe the case managers who have to now write up their notice of intent and also be in a hearing and say, this is clearly what the committee stated, what their direction were. And sometimes if we go too fast and we have to go back and say that wasn't clear. And what we try to keep it to a very minimum is coming back to seek that clarity. Because it delays it we will if it's so important, especially if it negatively impacts an officer's certification. But by having these very defined steps, I've also seen by slowing it down and having these discussions is some people are slower processors and others are quick because they just know and have an opinion. But if we take the time and let everybody have their say, I've seen more discussion and more diverse thoughts in these meetings. So I'm glad you find it to be helpful because that's the way we want to really continue to go.
I know we encountered some combined motions and vote in the last one.
Not very well.
And it on its face, it seems reasonable to combine a motion, but in the after effects, in the after effect, we realize that actually removes the opportunity for people to have a different opinion about things. So I think moving forward, it will always be a separate vote for taking action and a separate vote for the ineligibility period. Because everybody,
It's a mess.
right, everybody could agree that it was appropriate to take action, but they might have a difference on what the ineligibility period should have been, type of thing, so. Yeah,
the pause seems to engage more folks in the discussion.
so we appreciate everyone working through those flows with us.
In our onboarding, we're gonna have a Teams meeting to go over the scripts that you guys have been exposed to, and we're gonna just see if every chair, vice chair has any questions. We'll go over it to try and get consistency. And then as we onboard members, committee members will send it out too, because it's color coded to say, this is what we need from the committee member. Oh, I need to, vote on this or, negate it. So we're hoping it is just, a helpful tool. You'll see that coming up in the future.
All right, so what happens to a case when all of the staff identified moral fitness violations are negated? So the committee has said, we don't find dishonesty, we don't find misuse of authority, and we don't find misconduct. So everything's been removed. There's nothing to take action on. Our current interpretation, the current process we've been using is to say, okay, because this was a case that was presented to the policy committee, and the policy committee is supposed to be making a recommendation that would be sent to the board, we will continue this case on that path. meaning the recommendation from the committee is there's no moral fitness violation, therefore no action to take. So the question becomes, is that the appropriate course of action, that it continue on to the board for the board to affirm the policy committee's recommendation that there's no moral fitness violation? Or do we need to approach it from the idea of that administrative closure? That the committee's recommendation or finding that there's no moral fitness violation then turns it into an administrative closure. That's kind of what happens when all of the moral fitness is removed from the case. Thoughts?
Carol Bradford for the record. So when you were talking about this, I was like, there was another thing that closes, it doesn't go to the board, so it is the administrative closures. So what is the difference between your administrative closure or confirming the closure? And not sending, if we decide we look at a case and we are basically recommending administrative closure, we take no action. Does that need a checks and balances of the board? I mean, I guess that's the question that's posed to us. Or is there the trust that we're looking at it and that we make that decision that the board does not have to?
What's the difference, Scott, what's the difference between us recommending a 10-year and the board has to approve it? And us saying nothing and the board has to approve it? I mean, I lean toward the board approving it, but also the board doesn't have the same amount of information as, unless you request it. Your face value information you get is not as much as the policy committee would have. The discussion would not be as robust with the same subject matter experts as the policy committee has. So you're thinking that the group that took the most thorough look, was the most subject matter experts would be the policy committee that it went to. The board then is comprised of members of all of those, some of which may know about fire departments or may not. And so I'm a little torn because I do see the need for maybe an extra level, but is that extra level actually going to be a complete look at it, or is it going to cause more confusion for the board? Because they're.
So, I mean, the board does receive all of the same information. So everything that is given to the committee is then packaged and given to the board with the committee's recommendation on top of it. So they have all of the information, and if they felt.
And I guess by all the information, we don't have it's not the same, case explanation, the same
They have a
conversation.
staff report.
Yes,
Right, yeah.
yes, that's what I mean, it's not the same level of scrutiny of a case unless it's pulled and there's additional questions on it, so.
Unless you don't go for the record. So what you're saying is even if the policy committee says they're making a recommendation to close it, it still goes to the board.
Right now, because our process has been silent on it up until this point. So if it's an administrative closure that staff are recommending to the policy committee, the rule says that the policy committee, upon approving the administrative closure, it's done as final. That doesn't go onto the board. So now we've got cases that are being presented to the committee, and the committee finds no moral fitness violation. So then it just gets recommended as no moral fitness violation. So.
Rob Wood for the record. So on administrative closures, it's pretty black and white and objective. And then it comes to us for concurrence. But if it comes to us as a potential moral fitness violation, and we determine there is none, that right in itself implies that there's some kind of disagreement. And if I understand it, the committee is not a decision maker until the board affirms things. We're a recommending committee, right? So I'm thinking based on your question, which really was a statement, I think we should leave it as is. If we find nothing, I think it should still go to the board.
Captain Kaplan for the record. I have seen on occasion, where that time, right, from the time a committee makes it to the board, there's maybe 2 or 3 months that go by. Sometimes there's conversations that happen, that bring to the attention and the board then can discuss it. For example, I think the one that John talked about, where, the agency thought this is a no big deal, just go in front of them, you don't have to give mitigation, and they did a lifetime, and then it was like, oh, stop the press, we gave bad advice, we did this. They did that through the board, and then the board, when they saw that, kicked it back down, and they did it a whole different way. Got agency support, had the officer come in front, and it went from a lifetime to no action.
Right.
And so there's been a couple other times, I can tell you with my chief's hat, I've gone, what were you guys thinking? And I had an avenue of asking to look at this again. And it was the board then kicked it back down and had an opportunity for further discussion. So I've been on both sides of that, where it doesn't happen a lot, but you have that ability to have that second layer, and in between there is, what did we not know or see? And again, doesn't happen very often, but it's been advantageous for both parties, right? It could have been at this time, an officer benefited from that second review. Sometimes the agencies, their concerns were heard. So I can give you those two different perspectives as well.
Sure, Brad, for the record, so that is if it's found something, but this is not finding anything or recommending closure, right? No violations. Have there been cases, do you know, that the board has overturned a policy committee for recommending no action to taking action?
You want to look at both Jennifer and Melissa, if nothing's coming to mind
I
on
know
that.
the case that got returned, like the committee made a recommendation and the board had pulled it from the consent agenda, discussed it and returned it back to the committee for further consideration. But when the committee made the same decision and sent it to the board, they approved that recommendation the second time.
And when the board kicks it back, the board is supposed to provide specific directions on what the policy committee is supposed to reconsider. So what did they see that they thought meant it should go another way? So
with that information, I mean, I think this is part of the process, and that they should go to the board, so that process can be done. I don't think there needs to be a change. Seems like that.
I agree. I think that's what I said.
Right.
Could have got us out of here.
okay. Thank you all for the conversation. Like I said, it's a situation that's been silent. We didn't have specific direction on, and then it's come up and it's kind of like, okay, so we just need to codify the process. And so that we can continue to apply it in a forward motion. So it is 3:54. Our meeting ends at 4. We have several additional pieces to talk about, and we will hold those over until the next meeting because they deserve time that you can give and not to be rushed.
Thanks, everybody. Appreciate it.
Thank you. Oh,
Reach out.
any quick feedback on, so this is June, a July meeting or July meeting, no dice? Because it's July.
Nice.
Yeah.
Okay.
Sometime.
Okay, all right. So we'll
Just schedule now for August.
Yeah.
okay.
Early August.
That's fine.
Something.
That's legitimate feedback. Okay. All right. Thank you. I do have to stop the recording. Thank you. So we are still official. Stop recording. All right. There we go.